everybody. Welcome to episode 5 of the Ask a Human Answers to Unanswered Questions. I'm Trish McAllister, the State Bar's Law Practice Management Attorney. In each episode, we answer AI questions submitted by Texas lawyers in plain English with practical tips you can use today and clear guardrails so you stay ethical and effective. Today's episode focuses on AI in various practice areas. We are delighted to have Patrick Wright. You're so awesome. Attorney, mediator, tech master, who is board certified in family law and child welfare, here to answer some of the questions folks submitted that are specific to, family law, mediation, litigation, and sole practice. Patrick also recently co-chaired the ABA Tech Show in April. And they, of course, were smart enough to snag him to be now on next year. So that's the thing. You do such a great job, you're going to get roped into next year too. But before we dig in to the first question, do you have any breaking news for us today?
Oh my God. Thank you for asking, Trish, for that breaking news, because those of y'all that go to any of my speeches know that I always have a breaking news segment. And man, other than, I feel like naked up here without Alex, but I would say, if y'all watch our regular Ask a Human, that Alex is always here to bail me out of trouble. But I would say that, we have some great breaking news yesterday. So Google's been having their I/O conference, and in that conference is where Google sort of announces all their changes that they're going to be happening sort of over the next year. And man, what a big change they announced yesterday. So let's think about this from a search standpoint. So Google introduced a lot of their AI products a year ago. And let me give you some numbers real fast. So on their AI mode right now, they have that, that when you're doing your regular search, you can click that on, Trish, that they have 1 billion people, 1 billion people, and this is a year old, 1 billion people each month are using that product, which is staggering.
Oh my gosh, I had no idea. That's crazy.
Right. So overview, right? So people are like, I don't know if I want to use it. You're probably already using it. AI overview, which is in their search right now, 2.5 billion monthly users on that product alone. But here's where it really gets scary. So they've updated their search box. This is going to be rolling out between now and the summer for users. So what does it mean for the practitioner, right? I mean, this is like really scary news, because when you look at your regular web searches, and again, we're talking 24 hours. So, even a geek like me hasn't really digested and figured all this stuff. We could probably do a complete one of these programs on this alone, by the way. Maybe we'll just put that on our list. But so think about this. So if you're a small website and you've been getting, if you have 1,000 to 10,000 monthly visitors to your site, what they're showing is that where many of us over the years for business have used our websites to drive traffic. What they're showing is to small sites with the introduction of AI, 60% reduction in traffic over a year. Right. So mid-sized firms, 47% reduction of traffic, and even the really big sites are having a 22% reduction on traffic. So I say this only to start this program out like I always do, of trying to help lawyers and help practitioners, and say that if you didn't know that this search was out there, it's happened. It's going to be rolling out over the next year. If you were relying on your website for traffic to generate business, you got to come up with a new strategy, right? Yikes. Well, and one of them is, if you look at the search terms for sites like ChatGPT, Perplexity, those sites, their traffic for generating site to website traffic is up about 122%. So,
yes.
so that's what I'm saying. So there is some good news in this lining, but the other thing is we've gone from y'all. I mean, like, I'm an old time marketer. Like, at one point in time, we've changed up the search page so many times, where we had like the 10-pack and then the 3-pack, and then we had map ads in it, and we had all this stuff in there. Now it's gone to we're just going to ask it a question, and those listings may be degraded, or they may not be as prevalent. So if you were counting on think about the work of, if you were going to look for a law firm, you'd go search for you and your listing would come up or your website would come up. Now it's going to be sort of question-based. And so that being said, it's really something to put on your radar if you haven't looked at it. because not only is it going to affect how people find you, but it's also going to affect the information that your clients are searching about what you do and how you and the topic that we're going to talk about today. And you may have clients doing that and doing their own searches on the topic and then sending you information because I already have. But that's just going to keep growing. But anyway, I just wanted to put that out in the universe, have everyone understand it. That's a pretty substantial change. It's happened literally very recently, and they need to have that on the radar.
That is a significant change. So I am incredibly grateful that you have clued us into that because I had no idea. So people do need to be aware of that and act appropriately, take action so they can make sure that they continue to get, the clients they need. Well, let's dive in now, though, to some of the questions that people submitted that we weren't able to get to in our other Ask a Human webinars with you and Alex Shahrastani. So what is AI for the family law attorney, and does AI apply to child protective service practice?
So I can speak with authority on this because, number one, about 70% of my practice is family law, and about 30% of it is child welfare, working for, if I can speak, welfare, working with the Department and Child Protective Services. So I do both, and so I can tell you that. Let's start first with what it is, what AI is to a family attorney. I hear a lot of people talk about and describe AI as a tool, right? And so, to me, a tool is a garden hoe, or to me, people talk about, well, we had these tools in the Industrial Revolution, and, it was, we had the cotton gin and we were doing all these things. And I say, yes, but your cotton gin, your shovel never responded back to you and corrected your work. It never redlined your document. It never made suggestions to you about what you should change or improve. So I say, of course, it is a tool, but it's actually more than a tool. And if we look at sort of where it's going, it's, if we can say it this way, the worst tool it's ever going to be right now. All right. And so I say, what is it to the family law attorney? Of course, as I just said, that it is a helpful tool. It is an aid. It is, I always tout Ethan Mullick's book that he has on AI. And it's like co-collaborating, co-work is the title. And one of the things he has is how you co-work with AI. And so it is literally an assistant that you can use. So stuff you can use it for, and stuff I'm using it for, responding to emails, right? I use it to review expert reports. I use it to explain complicated topics to clients. All right. So let me give you an example of how you might use it in your practice so you can have at least one. You're going to have many more takeaways from this discussion. But let's say that you get an email from a client, and y'all know that we get these emails that are like 15 questions long. You're like, this person must have spent a long time. I'll tell you, most of them probably not. They're probably using AI to generate these, right? And so what you do is, if you're using ChatGPT, all right, if you're using OpenAI, the product, and we've talked, you got to know how to use it securely. Confidentiality is really important. Turn your training data off. All right, so make sure it's confidential. The system's not training on your system. And then you have to be understanding of what the rules are. 705 in Texas is the ethics rule on it. 512 is the ABA opinion on it. But understand that talks about, you have to understand rule 1.1, use of technology. You have to understand how the system works, how it's not storing your training data. Your training data is off. Even with that, there is still some concern about how you use the product and what information you feed into it. But I'm fairly confident that if you're using the paid version, which is another thing, all right? So we may talk about that in here. Y'all are familiar that we've talked about the Hepner case. You're familiar with that we've talked about before, the Warner case. And then the other thing I would say is the Morgan case is a fairly new case as of April 17th of 2026. And one of the things that the Morgan case said, which is very important for this discussion, is that there's a distinction between if you're using the paid version of the product or the free version. So I tell everybody, do not use the free version of it. In fact, I'm going to quote the Judge Braswell in the Morgan opinion, who said, if you're not paying for the product, you aren't the customer, you are the product. And so, yes. And so what Braswell is saying is, Judge Braswell is saying,
that's a good way to say it, actually.
Yes, because they're using your information and you're the product. And so you don't want to be the product. So client gives you an email, you got all those safeguards in place, your safety, you dump the email in there. I'll tell you a secret trick. which is you can either use the regular search term, just the regular chatbot feature, which is in there, or if it's more substantial, you can use a project file, look on the left-hand side, create a project, name it, and you have a limitation on the amount of names you can use. It's not going to be that big. Let's say it's a Smith file. You put the Smith file in the project file. You load it in with what your pleadings are. They're public. You load it in with what the email is to the extent you have it. And then you write in behind the email what you want your response is. It may be 10 questions. You write in. It doesn't have to be great spelling. It doesn't have to be perfect grammar. It just has to be the response. And then you say on it, you can give it a role. I mean, you don't have to do that as much. If you put your personal preferences in the document, you've told them that you're a family law attorney in Texas, and you've told them those things, you don't necessarily have to do it. I would say this to everybody: always don't assume that it's going to correct your spelling and grammar, because it doesn't always correct your spelling and grammar. So if you want it to correct your spelling and grammar, put that in there too. Type all that in there, hit response. Then it's important to know what training model you have it on, because you can use an instant, which is going to be very quick, less thought, or you can use sort of like the pro power version of it, and it's going to think for a time. So you have to be cautious, because if you really need an immediate response and you hit that pro one, you're going to be like, oh my gosh, because now, I mean, you could be sitting there for 30 to 40 minutes to get that response, and then you're going to get a very detailed response. Now, the other thing I'll say to that is it doesn't mean just because, and this is, I think, the mistake that most people make. People are like, they've heard all this stuff about AI, and they think it's going to give me the most perfect thing ever, right? Then they get it, and then they're mad about it because they're like, oh, this didn't. Well, go in, you can edit it, you can ask the process the system to make changes. You can take stuff out, you can add, you can remove. And then you just do like you're working with a legal assistant, because now we've got your sort of AI legal assistant, and then you're using that to get a product. All that I just described is a fraction of the time it takes to do it, right? So my description took longer than it would take to do it. I have literally, y'all don't think I'm creepy on this. So I get my legal assistant's emails, all right? So it helps if they're out, it helps if they're busy. And so clients will send my legal assistant something, and I'll get it at the same time. I will sit there and do my own AI response to see if I can beat them. I know I'm a geek. To see if I could beat them out the door and getting the response, and then compare the response to theirs, right? I'm telling you right now, mine is quicker. Mine is always better, right? and so that's one way you can use it to respond to emails. I'll give you another way that I used recently, and this may also overlap if we talk about trial, which is expert reports, right?
Yeah.
So if you get an expert report from a financial person, because I had this in a trial, and I get the expert report, and then I put the expert report in the project file, and I have my system go in and be a counter expert and do an analysis on that expert's report. And then I'm going to give you sort of another pro tip.
That's a really good use of it. I mean, honestly, I love that use of it, because it just.
But let me tell you this, though, and this is craziness. So I did it the other day, and, and some of these reports on financial stuff or analysis that are people doing, we're talking 20, 30, 40 page reports. And it went through and it told me all their misspelled words. It told me like literally stuff that I was like, oh my God, I missed this, because there were parts where they had done financial analysis and they had put wrong, commas in there and decimal places were wrong,
Wow.
Yeah. Where it says example, like someone should get 200,000 and it was like 20, I mean, and it was like, it was crazy. They had misspelled my own experts because it was a response to my experts. They had put my own expert's name. They had spelled their name wrong many times. And so that's the reason why I'm saying something like that could be really damaging. Now, if you really want to get fun, what you can do is, I'm going to tell the secret, and the state bar is going to be like, what? We're going to have to look at that. So if you're a state bar college member, or you pay for the online library, right? With the state bar, you can go on to an online library, and it's just an amazing product. You can have access to y'all know this, all these CLEs. If you take those CLEs on your topic, and then you create a project file, and you put those CLEs into the project file, and then you use that information, which is the most current analysis of what the state of Texas law is on any given topic, to go after and to critique the report of the expert, it's amazing, because now it decreases hallucinations. You've got a controlled
Mhm.
environment. You're using, Texas subject matter, very current material, and then you're using that in this closed system in order to be able to do analysis on the report. It just is absolutely amazing to counteract an expert's report. So those are like two quick ways that you can use it for AI in your family law practice. Let me tell you about child protective services stuff. And so on that, again, you have to be, so I'll tell you this. So I see a lot of caseworkers now that are using it to do case summaries and sending them to me, right?
Right.
So not only is it that the lawyer is using it, but we've privatized.
Everyone's using it. Yeah.
Yeah, we've privatized the system. A lot of these folks have to give reports. I'll get, and it varies by who the agency is, where you are in Texas. And so I'll get this report from the caseworker, and I can look at it and be like, they're using AI to give me the case summary on that. So now, what you could do with that, number one, you have to be very, very careful about confidential information. All right.
Yeah.
But like, here's one example. Like, let's say, because our AI system could be anything. I was talking to a group of mental health professionals last week, and they were like, "So you're putting us out of a job, right?" So let's say that I get some blood work, some blood analysis on any kind of drug test, right? And Patrick's like, "Is that bad? I don't know if that's bad. I don't know what that number relates to." And so I can have my AI system be a drug and alcohol expert and then go in and do sort of the toxicology on the report and tell me, do an analysis on it. Like what does this mean? If, how can I use this in court? Like when's last use? I mean, really detailed analysis, right? And it's pretty good. And if you say to me, well, how did you figure that out? Like, how did you come to do that? I will tell you that my wife got some blood work on like a Friday afternoon, and cancer survivor. She had colon cancer before, doing well now. But she got a blood test result, and she was like, I don't know what this means. This is good, bad, whatever. And instead of worrying all weekend, popped it in the system, said, here's all the features of who the patient might be, right? And so give me an analysis on what this means. And it came back and said, nothing to worry about, no concern, She still checked with her doctor and everything. But I'm just saying that it's really good for doing those analysis. In fact, and I'm trying to think of the product, we don't have access to it because we're not MDs or medical people, but there is, I think it's called Open Evidence, maybe. There is a platform that doctors are using. There was an article about it over the weekend, and I want to say like 60% of medical professionals are using this product to do analysis on their patients. It's very popular right now. Yeah. And so that's the reason why I'm saying, so even the doctors are using it. So you can use it in CPS cases for that. You can use it for summaries. You can use it if you're doing a hearing and you need to take those affidavits that you get for the removals or these case notes. You can also put it in your closed system and then also have it do a Q&A questions and answers for, the caseworker if you have a hearing. Many places are different. Like in where I practice, we have hearings on almost everything. Some counties don't do that. But for me, Trish, if I have a hearing and they're normally fairly quick hearings, I just need something spot on to bring with me. So if that judge says, I want to hear some testimony, I've got something with me that I can fall back on. So it's just not off the top of my head. And so that's the way that you can use it, but you can definitely use it in CPS cases.
That's a great idea because, especially it does. I mean, I've used it myself for medical stuff. It's really pretty accurate. I got to say, it's super helpful. So those are great ideas, Patrick. Thank you. All right. So let's move on to the next question that someone asked about. How can I leverage this in mediation practice, and what are the concerns or applications of using AI as a mediator?
I mediate as well for folks, right? I don't know. So I may talk about some products on here. Understand the state bar is not endorsing these products, right? I want to be clear on that. And I'm not endorsing these products. I'm just giving them examples to you. And so don't call me up and be like, I hated that, it didn't work or whatever. And the other thing I'll say is these products are created
constantly changing.
Yeah. And they're constantly, they may be bought out by another person.
That's
the
true.
Name may change. So just understand I'm giving these to you as examples, but don't send me
as
hate
of
mail.
Today.
Yes, as of today. Yeah. Don't send anything to the bar, right? Because the bar definitely is like, the bar doesn't even know what I'm going to talk about right now. So it's not me or the bar, but we're not endorsing anything, just so you know. Okay. But that being said, so like of all things, very recently, this isn't mediation, but it's arbitration. The American Arbitration came out with their AI arbitrator, right? So just came out with it, yes, to use in limited situations to help arbitrate. Now, that being said, I want to give you some practical uses that you can use for that's not arbitration that we're talking about mediation. Okay. Number one, like as a mediator, it's amazing the amount of times I get absolutely nothing from lawyers. Not to say that lawyers are that's bad, but maybe you guys are busy or whatnot, but I don't get anything. So you show up and you're like, and it's me doing a debrief, right?
Right.
So for years, I've always talked to everybody about doing a position statement, doing a summary from your mediator, right? You can use AI right now to, create that project file, get your clients. I always tell my clients, like, look, you know what? The mediator may not be warm and friendly. We try to fit the mediator to the personality. If we're picking somebody, I know we all do it. I do it, right? I mean, you don't want to get someone that your client's not going to gel with. You try. Sometimes you want the person to be very tough, right, on your client too. I'll say that too. But have the client write out, if you were in mediation, what would you want the mediator to know if they didn't ask? And then, make it 2 pages. If you send me a 20-page paper, I'm not going to be very happy. But I'm just saying, make it a summary sheet. Take that summary sheet, because normally y'all know most of the time the stuff we get from clients is not exactly letter perfect. It's not grammatically correct. Sometimes that may be helpful, but take that summary from the client, put it in the AI, project file, put any other information you have in there, and then tell it, hey, I'm going to be going into mediation. The mediator needs a summary. Act as a Texas board certified family law attorney, I need a summary of this to tell the mediator about my client. Boom. There's your summary. Send it to the mediator. That knocks out one thing. Now, next thing, maybe you want to load it up with your information in your client because you want to do a mediation checklist, right? Yeah. Identify what case issues I have, right? Maybe you want to do the strengths and weaknesses of your case, right? So, yeah. I was amazed. I did this the other day, not in mediation, but I'll just tell you something that it can do, because I'm amazed at the stuff that comes up with every day, which is that I was looking at a summary judgment and I was comparing some summary judgments. And then I had it grade the summary judgment and give me an estimate on what the chances of success or failure was on each argument. And it actually gave me, you have a 75% chance of prevailing on this point. This is a horrible point. You're going to lose on this. Yeah, I'm not serious. Yeah. So it gave me like all these points. So it ranked it, right? And so that's the reason why I'm saying, so 1 summary, 2 mediation checklists. You can do an issues checklist for what are the issues in the case, and then do a response for them. And then I'll tell you the other thing that I've been doing, which is kind of funny. But this is like post-mediation. So let's say you get a mediated settlement agreement, and then the other side drafts a decree, right?
Right.
So again, you create that project file, put the decree in the project file, take your MSA, put your MSA in the project file, and have the AI compare the MSA to your decree and see if all the points from the MSA have been put into the decree.
That's good.
So you can use it to compare.
Very practical. Yeah.
Well, and I say this to everybody too, which is at some point, not now, don't send me letters, don't send Trish letters on this, but at some point in time, it probably is going to be under Rule 1 and competency. It's probably going to be mandatory to use these systems to check this stuff.
Yeah, I mean, we the last episode we did was an ethics one, and we were talking about that at some point you're going to have to be competent, because you have to, if not just for using it yourself, you're going to have to make sure that to be able to defend against opposing counsel. So
I got to tell you one thing real quick before we move on from this topic, right?
Yeah.
So there's a product called ZODR.ai, right? Now, let me tell you what this does, and this is what makes me nervous, right? So we're all doing these Zoom mediations, right? So the ZODR, if I can say it that way, it integrates with the Zoom mediation, and it acts as a co-mediator with your mediator, right?
Really?
Yes.
And how? In what way? So tell me more about that.
So it listens to the conversations, makes me nervous, right? Yes, it listens to the conversations, and then it's on the mediator side, and it sort of helps co-mediate and gives comments, and I mean it's like a whole built out system. Not only does it, but it takes payment. It'll do scheduling. It actually, yes, yeah. I've never used it. Don't write me on this. I've never used it. So when So Tech
That is a
Show
little
has a,
creepy, but it also could be, very helpful
it
in
could
so
be,
many ways.
but I'll say this too. So how I found this was, so at Tech Show we have a startup alley, and different tech companies for lawyers pitch their products, and so it was in one of the submissions for Tech
Oh, okay.
Show, very in March, and so it's not very new from a product standpoint, but I haven't delved into it. From It would make me very nervous from a confidentiality standpoint,
Yes, exactly.
because mediation is supposed to be confidential.
Yes.
Right. And so, if I allow, there's some cases out there that it didn't reference, like all those ones I've mentioned, like Hepner and Warner, Morgan, those cases. One of the things that in the Morgan case, I believe that the judge was saying is this, that you've turned your information over to a third party, right?
Yeah.
Well, to me, like, in Warner, what's the difference between turning it over to a third party in that context and then turning it over to a third party, like a AI, like a system that's monitoring what people say, right?
Right.
I mean, to
Exactly.
me, that seems problematic. I haven't delved into that yet, but there, just understand that if you're mediating, I mean, maybe we need to start asking these, mediators or people, are you using any AI systems in
Yeah.
your system?
Yeah. I mean, I think there may need to be some thought put into that before you start having that come to your mediation, but
Yep.
yeah, for a variety of reasons that you've mentioned.
Yep.
Um, but it is pretty interesting. So, okay, let's see. Moving on to our next one, which is, as a sole practitioner, what AI must I use? What's the cost, ethics, effectiveness? Just tell me anything you had about it.
Okay, so I'll just give you my bullet points on this. Number
Okay.
one, you don't have to use any. So just so you know,
Right
so
now,
yeah,
right
yeah, so
now.
yeah, right, yeah, right now. So if you look at 705, and even if you look at 512, the ABA opinion, and even other states I've seen, I mean, they're pretty clear. You don't have to use it. So we're not saying that you have to use it to be, for your practice. You don't have to use it. But if you do use it, you have to use it ethically. Now, the really easy answer on the ethics stuff is the same rule of ethics apply, right?
Yeah.
So the same rule of ethics apply. So one of the things just that I was just doing was that we just rolled out. We had a meeting on it last night, so I'm a member of the American Academy of Matrimonial Lawyers. We have bounds of advocacy for how family lawyers are supposed to practice in America, right? So it's a document. It's been in existence for 20 years. I think it's been updated once, and so about 6 of us sought to rewrite this document to bring it into the 21st century. And that's one of the struggles, among others, which is how do we wrap technical competency into this document for the practitioner, understanding that it changes about every 5 minutes, right?
Okay,
And
yeah, yeah.
so the issue is we acknowledged it, but we also acknowledged the fact that the same rules that you have apply. So if you know the rules, you don't have to go take a new ethics course. It's just applying the existing rules to the new technology. But you have to have some basic knowledge of the technology. And I'll say the asterisk to that is you don't have to be a coder, right? So
Right.
you don't have to have a CS degree, computer science degree. You don't have to have that, but you just have to know how to use it. The main thing is you have to know what they're doing with your data. You have to know what the terms of services are, all right? Because some of these terms of services and the practical use of them, people are doing things, or the companies are doing things with this data that no one even knows about, and it's buried into the really fine print on there. So I would just say, just need to do your due diligence and see what you can figure out about it. Now, cost, paid version, we're talking $25. I will say this though, in that range, I will say people are always like, what product should I use, right? So I really have thought that recently the sort of the big products, the Anthropics, the Claude, same thing. That's who owns it. OpenAI, ChatGPT, that's that product. CoCounsel, which is a West product. If you look at what am I thinking of? Microsoft Copilot, it's
Right.
another one. I mean, all these sort of big products are going to do a lot of the same stuff, right?
Right.
If you said to me and then some of like the big 3 have very similar things, but they just may call them different things. I mean, most people are going to have a chatbot feature. Most
Right.
people are going to have, a pro, I'm trying to think of what we used to call it, a research model, right? Like
Right, right.
there's some that have deep, that's the tab, deep research. That was, it used to and people still argue with me about whether it has a deep, open has a deep research. It does, it's buried in there. But their pro model is, they phased out the term deep research and they've gone as pro model for search. But, Google has a deep research function, and then, so that's the chat, right? And then they have like this program feature that would be like Claude Cowork, right? And so
Right.
if you're looking at Claude, and then most of them have a coding function like Claude Code. Even the Google rollout that I just mentioned earlier, that they're going to a coding function too, which is kind of dynamic. That apparently they're only going to offer it to the paid users first in the summer, but then we'll see where that goes. But I'm just saying most of them have the same type stuff. So
Right.
so what you want to do is, and I'll say this to everybody too, which is, ethics 705 in Texas, 512 ABA. Read those and understand them. There may be some other ethics opinions that are coming out. I know that Trish, that we talk about that occasionally for our law practice committee for the State Bar of Texas about what other things we may want to look at. I know that other states have looked at stuff too, but then in the effectiveness of it, there's a huge difference. Number one, don't use the free version. But if you're using the free version, then you're the product, like we said. So don't use the free version. Pay the $25. But there's a big difference on these between like even the free version and the pro version. There's a vast difference in the models. I've talked about this in speeches before, but people are like, oh, this thing's horrible, whatever. Well, you're probably using the free version, because I'm using the most expensive version besides the coding version that I can get, and I can tell you it's phenomenal, right? So it's a really good product. So how effective is it? Extremely. I mean, it'll save you time. I mean, think about this. Like, let's say you had a research project you had to do, or you had an analysis you wanted to do, or you wanted to do your cross-examination, right?
Right.
Put your information in there, give it a decent prompt on doing crossing, hit go have dinner. And I'm not talking about making yourself a ham sandwich. I'm literally talking about leaving your house, going and having dinner at a nice restaurant, because it's probably going to take about 45 minutes, to 50 minutes if it's really going to do that search. Come back from dinner, open it up, tell it you want a Word version. You got a Word version, right?
Yeah.
Now it's been working and putting all that stuff together while I've been doing something else, right? I'm always, not right now, I'm not doing it right now, Trish, but a lot of times if I'm doing something in the background, I've got it working on a project. So, like people are always like, how are you doing this stuff? Like, do you ever sleep and everything like that? Well, what I'm doing is I'm maximizing my time by having AI do a lot of these functions that would literally take hours, right?
Yeah.
True. And I'm thinking, I think you have to be playing with it, right?
Yeah. Yeah, exactly. I mean, that's the kind of thing I think that people forget. It's that, there are some risks involved, and there's a lot of fear around all of that. But if you minimize those risks by doing exactly what you say, get the paid version, make sure everything's turned off, you're not the product, all those things that you've been saying, the upside is huge, and you still may need to spend a little bit of time, and maybe it's not exactly perfect, but it just saved you 5 hours, and maybe you have to spend an hour with it now to massage it to be exactly what you want, if that.
I'll tell you, we're not there yet, right?
Yeah.
But we're going to have a discussion at some point in time about how we bill our time. All right.
Well, we are getting, it's funny because some people were asking that question at the last webinar we had, is like, how do you bill? People are starting to ask, how do you bill appropriately for all of this? And that's not for today, but it is something that is on the horizon, because one person was like, I feel like I've reduced so much of my work volume that, I don't feel like I can even bill anything anymore. So it was having a little bit of a crisis.
Someone's going to ask, I know, Trish, I know someone's going to send something in. They're going to be like, well, when you were at dinner and that thing was doing all that work for you, were you billing for that? And the answer is no, right?
Yeah.
Yeah. So, because I've had some people who have been like, well, I'm still going to bill even if it's doing it. And I'm like, you can't do that. You
can't do that. Yeah.
And so I'm like, you can't do that.
Yeah, no, that's been kind of the conversation a little bit, is people grappling with the fact that they're more efficient, but that also means that they've just cut into their billable hours.
but here's my thing is, that means, and I'll say this too, and then we can move on to the next one, because you're right, we're going off topic, but we do occasionally, but it's all good. But yeah, so I think what it's going to do is is everyone thinks that that's a problem and I'm going to have less time. No, it's not, because what it does is it gives you more time to have face-to-face with the client. And so, yeah, in the future, that's where the money is going to be.
Well, and that's the thing, because you need to establish those relationships, and that's what your clients want. And they will then go to say to every other client or every other friend that they had that he's the kindest, nicest guy. He spent so much time with you, because you're having you're having AI do some of the routine tasks that you used to have to do. For a litigation practice, are you using AI to help draft discovery responses? And if so, what's your method?
Let me tell you about this on litigation practice, and then I'm going to give you a couple of products, and then I'm going to tell you sort of a new thing about it. So I want to say it was this last week or the week before, Claude came out with 12 practice plugins. All right. So 12 practice plugins. One of those is a litigation plugin. All right. So I was looking at it before this call because I wanted to see if they had a specific family law practice plugin, and they don't. They do have a specific litigation practice plugin. And I will say, if any like legal aid folks are watching this or whatever, they do have one for access to justice too. So understand. Yeah. So if you're looking for access to justice, there's something there. If you're a law student, they even have a law student mode in there. So that's pretty cool. But they have they have 12 practice plugins. I'm sure they'll add more. They have 20 different plugins that are MCP. And if you want to know what MCP is, go back and look at our thing on MCP, right? Because there's a video.
Model Context Protocol.
That's right. So Alex educated us all on that. And so go back and look at that video.
April 19th webinar video. Yeah.
What day was it?
April 15th. Sorry, tax day.
Okay. But check this out, Trish. This is cool. So the MCP sort of plugin, right? I'm just going to give you a couple of products that they're plugging in with now. West. So they're plugging in with Thomson West for legal research, right? So let's say you're doing something and you do the MCP, basically for those out there, we're letting one thing talk to the other, right? So let's say you're giving it that thing like, I want you to do research on this brief, and you essentially put the link in there to Westlaw. Now it'll connect to your Westlaw account and it'll do the research for you while you're at dinner, right? That's one. Yeah. The other thing is it connects to like Harvey, like these bigger platforms that lawyers are using. And then it also now too, because I looked this up too, it connects to DocuSign, right? So yeah, so if you're using it for DocuSign, so that's 20 different MCP plugins that they had. I'm sure they'll come up with more. Oh, and I'll tell you another one too. So because may talk about it here somewhere in this stuff. So Describe is another product that now it's describe.com. If you ever used it, AI, they've changed their domain, but they also are a cheaper version of legal research than West. And they also have an MCP with Claude, which I just realized this morning when I was looking, because it changes by the second. And so they also have that. So if you're looking for a cheaper legal research product out there, then they also integrate too. And 80 other integrations with other products like Word and stuff like that we use. So Claude really, in the past couple of weeks, have really sort of added all these add-ins because they're going sort of after the legal market. And so people are like going, what version should I use? I still think OpenAI has a lot of good products. What you're going to see is it's like you're watching a horse race. You're going to see one horse is going to get a little bit ahead of the other one, and the other horse is going to race out in front of him. And then you're like, oh, I want to go over here. I'm going to jump on this horse. And then this other horse is going to be ahead, and like, oh my God, the horse I just jumped off of is not it. So I'm just saying, don't drive yourself crazy like I do. That's going to happen because everyone's competing with each other right now, right? And it's even probably going to get more so because even this morning while we've been sitting here and doing that, then OpenAI has announced they're probably going to go public within the next couple of weeks. And so, yeah, so so now, like, goodness gracious, like, how much infusion of money they're going to have and what other things they're going to add, which is probably going to be pretty interesting. But to answer your question on drafting, there's another product called BriefPoint. Again, you can use it. BriefPoint will actually draft your discovery for you. It'll put your objections in there for you. All right. And that's so, great. but for that, I would just say that, you can use it. Like if you need a question like on something, like anything, like if, I mean, we get so used to using templates a lot of times, but if you have a case and you're like tired of it and you want to like really throw the person off, then you can have it come up with like your own discovery questions. I'm basically just following the Texas rules of procedure, the Texas rules of evidence. You can put all that in there. You can put some initial facts and have it drafted up. So I would just say this about everything, which we always say is it's not, I hear some people say, oh, you can just plug it in there and it'll be ready by the time you're at the courthouse. No, it won't. Right. And so it's not going to be that way. It'll give you a good start. You can look at it, you can modify it, but what you should never, ever do is just trust that product is accurate. It's trust and verify, as my friend Reggie Hirsch says. Trust and verify always on that, because the mistake a lot of lawyers do is they just submit whatever it is, and essentially that gets them in trouble or sanctioned or both. And so you don't want to be that person, because you're probably going to end up in the news. And so but that sort of, you can use it for almost anything for doing. I will say this on Brief Point, that it'll even do your objections for you. It'll dumb down the questions in non-legalese and send it to your clients. And then your clients can fill in the answer, and it comes back and populates. I'm not a big fan of their objections, and truth be told, because it'll like put like 5 or 6 objections in there, and it really looks a lot like the old way we used to do objections back in the 90s that we're not supposed to do anymore. And so I would just say, don't just blindly, have it put objections into everything and assume that those are all right either. So you gotta be the human in the loop and look at the stuff.
Yeah, I think it's true. I mean, it's interesting, because I do think the more you use it, the better you get at prompting, I think, is really the issue, and that it gets better and gives you better deliverable. But, I've been using it for a while now, and the other day I was using it and I was so disappointed at the results. And I kind of gotten lulled into thinking, oh, I'm only going to need to spend maybe, 30 minutes on this cleaning it up. But in fact,
So I'll tell you this, Trish,
need to scrap it.
Yeah, because I use it for almost everything, right?
Yeah.
I mean, planning a trip, I like my graphics. So, from doing speeches, so I'll use it for graphics, and I'll use a bunch of different ones for doing graphics. It's amazing sort of sometimes the inconsistencies that the different platforms will give you. And don't assume that, like you're saying, because I think that's the reason why I'm hitting on this. Don't assume if it just does some fabulous job on Tuesday that when you're using it on Thursday, you're going to get the same fabulous result. I think it probably has something to do with what they're doing with their model or their bandwidth or their servers or whatever. I don't know. Someone that's smarter than I am, maybe Alex can tell us what that is. But I'm just saying, because they're and it always seems like it comes when they're getting ready to release a new model, right?
Interesting.
Yes. And so, and I'll tell you this too, just on graphics.
Well, it's calculated is what you're saying.
Yeah. And I'll say this too. There are some platforms that will reject something. Example, I was giving a speech yesterday to the collaborative lawyers, and we were talking about IVF. And it was on embryos. And so the president had signed an executive order on it, and I wanted a picture of the president, right?
Right.
Google was like, even though this person's a public figure, we can't do it, right? I'm like, the president, right? I go over to OpenAI, great picture of the president, right? And so I'm just like going like, don't assume just because one platform says, no, you're violating our terms and services. Because I also wanted a picture of the Simpsons, right? This probably did violate something, but I'm just saying hypothetically, I should say hypothetically, one platform was like, no, this violates our terms of service. The other one gave me an image that looked like the Simpsons, but I'm just saying, so don't assume just because it won't do it.
Yeah. Okay. Good advice. All right. So one final question for today, Patrick. Using AI note takers and transcribing client calls. What say you on the matter?
All right. So I want to tell one other way, if I can, before note takers. Can I say one more thing? Do we have time?
Yeah, sure.
Okay. Because I want to say.
Oh, wait. Yes.
Because I want to say this one, because I was telling someone about it recently, and I'm like, wow, can't believe it'll do it, right? So this is back to that litigation topic, and
Yes.
this is a question of um of and I stumbled upon this, right? So if you and you're using OpenAI, and if you put in there what your case is, and if you have your information in there, and if you use trial notebook mode, right?
Yeah.
Now, y'all are going to look at me and you're going to be like, where's trial notebook mode? I just made it up. Someone asked me about this before and they're like, can you give me your prompt? And I'm like, I made the prompt up, right? So it's not like you can find it somewhere, but anyway, you're going to do trial notebook mode, like really like do this in a trial notebook format is your prompt, right? And you're going to say, take this information, act as this counsel for this person. I need a direct examination, use this information, give me questions and the answers, right?
Yeah.
And I need it in a Word format, using the Texas Rules of Evidence and Civil Procedure, right?
Right.
It will give you a trial notebook format.
Wow.
With the rules in it, who the parties are, like questions in it. It's just like amazing, right? And I've duplicated this so many times that I'm like, oh, I'm just going to call this a trial notebook feature, right? Now,
right.
I'm going to give you this. I'm going to give you the converse.
Just to be clear, that there is no feature like that. Everybody has to put that in there themselves. Yeah.
Yes. Don't write me and be like, I can't find what you told me. You don't know what you're doing, right? So, and I'll give you the other one, but this is like so basic. It's really funny, right? So these people may Roger may look me up or whatever. So y'all remember law school, and you remember, I think it's Irving Younger who wrote the 10 Commandments of cross-examination. Yeah, it's famous, right? That's the one, like, don't ever ask a witness a question you don't know the answer to. I mean, that's where that's coming from, right? So when you're doing your cross, right, I'm like, I want to be Irving Younger, right? So I'll put in there, I want to be Irving Younger. And then I start thinking, wait a minute, because he still does trainings. Roger Dodd, if y'all have ever seen Roger Dodd do training, he's come, I think, to some family law stuff, but he's mostly, he does personal injury. So probably all the PI people may know who Roger Dodd is. He's written several books on cross-examination. He actually, if you haven't seen him live, it's better than a comedy show. He's awesome. So I've seen him a couple times. And so anyway, so Roger Dodd's great. So then I thought, well, can I be Roger Dodd, right? And so, because think about it, he's published, he has a lot of stuff out there, content. And so I wanted to be a compilation of Irving Younger and Roger Dodd, right? And so I did my cross-examination, and I had it write it up using all the Texas rules and everything, and being Irving Younger rules and Roger Dodd. And it gave me this like literally brilliant cross-examination using their techniques, right? Now, y'all are going to be like, well, but have you ever used it? Yes, I used it in trial last Friday, right? And it was great, right? I mean, it like really did. Now, I mean, people that do trial work, that I just didn't sit there and read it like it was Romeo and Juliet, right? But I'm just like saying, from a context of an organization, it organized me. It let me think about questions I was going to ask. It gave me hypothetical answers that someone might say. I mean, it was fabulous. Try that out. I wanted to hit that before I went to note taking. And so,
thank you for doing that.
But seriously, try that mode and tell me if it doesn't work. If it doesn't work, then call me and I'll walk you through how I do it and I'll show you how to do it. But I'm just saying, I'm telling you it works. So go ahead, Trish. Sorry.
No. I was just saying thank you for doing that, because I, completely forgot about, asking you about litigation stuff. So, so now we can move on to we can just wrap up with your thoughts on note takers.
Okay, this is the bonus question here for the time we have, but okay, note taking. So the reason why that I was talking about and thinking about note taking is there was a May 9th, 2026 article, and I want to say it was New York Times. Yeah, in the New York Times. And the Sarah Kessler was the author of this article, so we can give her proper citation and credit for her article. But the article title is, and it's in the deal book section, was "All Those AI Note Takers ? They're making lawyers very nervous," is what the title of it is, right? Yes. And so they're talking about this trendy productivity hack where all these note takers are capturing everything that goes on, offhand comments and meetings. Now, a lot of this was in a corporate context of, if I'm a corporate lawyer and I'm advising a company, do I really want every meeting that we have recorded? Because think about all the problems that can create for HR, right? And so the analysis is shorthand, no, but what got me thinking about it was that how many of us are using note takers for what we're doing, right? And so the interesting thing was I mean, I use it all the time for recording client meetings, right? And I have yet, so I've been doing it like someone called me up and they go, hey, I have a really great idea. What do you think about recording a consult and then transcribing it? And I'm like, I've been doing that for 2.5 years, right? So I think it's great. And so, but the only reason why I say that is because you can use it for a lot of functions. There's a difference between having a group meeting, like I was talking about someone recording a mediation, which I think causes problems, and the other thing about it is like for CPS, because we talked about that earlier.
Yeah.
Like we have these like permanency planning conferences where we have everybody on this call, right?
Yeah.
Right. I mean, sometimes I've seen where we'll have a call where we're doing like an ARD meeting or something with a school.
Right.
And we're inviting the kid in, or we're doing a session with the child and we're inviting the child in. There's multidisciplinary team that are dealing with it. And then I'll look on there and I'll be like, wait, who is this person? Right.
Yeah, right.
And sometimes it's not a person, it's someone's bot, that their note-taking bot they sent to the meeting. That is a huge problem, right?
Yeah, well, that is a problem.
I mean, especially if we're dealing with minors, confidentiality, and then people's privacy, because some of those calls, we're talking about a lot of very sensitive things. You keep talking about, mental health issues, drug and alcohol issues, children. I mean, I'm just saying, just be very clear that if you're in those meetings, that you're that you're being cognizant about who is in your meeting, right?
Exactly. I'll tell you, that can be hard to know in those big meetings too. Sometimes they, if there's a crowded screen, you can't always find them.
I will tell you this: there have been some organizations that I'm in that we have banned bots coming to meetings, right?
Yeah.
Because I think there was one conference call I remember. I won't say who the organization was, but it was not the State Bar. But I'll say there was one organization I was in, and we showed up in the meeting. There's like 2 people there, but there's like 10 bots there, right?
Yeah.
It's like everybody's like, oh, I'm the only person who's not going to go to the meeting. We'll just send my, chat bot to it. And, apparently the chat bots are going to be talking to chat bots. But before we go, I got to tell you one thing. So I went to look, and the New York City Bar Association has actually done a professional ethics opinion on this topic.
Oh,
right?
Really?
Yeah. Oh. So, and the question is, what ethical issues should attorneys consider when using or when clients use AI-enabled communication tools that can record, transcribe, and summarize conversations with clients, right? And so what they reference is these tools are becoming more prevalent. They're expanding ethical issues. And then I'm just going to flip to their summary because we don't have time for me to read all 8 pages of their opinion, right? But one of the solutions to this is number one, they say as a threshold matter, both ethical and legal concerns require lawyers to notify clients in advance. This is in New York, not in Texas. So, it's in New York. So, but anyway, understand they're saying for their jurisdiction that you have to notify clients in advance of the conversations will be recorded and generating AI summaries, right? And then be concerned about confidentiality, competence, which we've talked about here today, and then train your staff so that people know how to use it. But this is my takeaway for it, which is it says in it that one solution, I'm just going to read, one solution is to craft retainer agreements that seek to preclude, check this out, clients from using their own AI tools in conversations with attorneys and provide that any recordings will be done by the attorney's own AI tools. If, however, clients refuse to agree to such terms and insist on using their own or commercially available AI tools, attorneys should affirmatively disclaim responsibility for unreviewed AI-generated summaries of the conversations and otherwise warn clients of the potential loss of confidentiality and privilege from using such tools. I would probably bet that none of us have that term in our fee agreements, other than the concerns about speech and all those other things that people are going to write me about. But I'm just saying that is a very specific response to that. All right. Because I can tell you that if you look at 512, the 512 opinion, most people come up to me after a lot of speeches and they say, hey, do you have a paragraph I can put in my fee agreement? And 512 seems to intimate that just putting it in your fee agreement is not enough.
Not enough.
Yeah. I mean, you have to have that discussion with your client about what it means and how it's used, et cetera. The only thing that I think this New York opinion does, which is pretty helpful, is recognize that it may not be the attorney that's doing the recording.
Right.
Your clients, which you got to be understanding with, your clients may be recording you in these discussions and transcribing your discussions. And so you may want to disclaim that as well. And then my last point on it is I've talked to a lot of judges who are highly sensitive and understanding of people bringing these devices in their courtroom and recording court proceedings. And it happened probably about 2 months ago, where someone had a device and was recording a judge, we think, in a proceeding. And, what are you going to do with that? Are you going to put it on YouTube? Are you going to put it somewhere? It's just, and we all know who the official record is. And that's a court reporter, not what someone has in their pocket or on their lapel. And so just understand that stuff's out there, and that's probably just going to get worse. But I was able to find this New York Bar Association opinion. If you want to email me, I'll send it to you. But if you want it, but I'm saying there is at least one opinion I've been able to find on these tools.
Wow. Thank you so much, because that was really thorough. And I do think, these questions are starting to come up more as, these issues of privilege, what's going to break that privilege, become a little bit more murky too. So really good that they came out with something, even if it's, not specific to Texas, at least it gives some guidance. So thank you so much, Patrick. It's been lovely and fun as always, and super informative, really informative. So I'm grateful to you for coming, and I'm so glad that you have such a huge knowledge base and that you're so willing to help us out. And thank everybody for coming and watching these videos. And, remember, if you have any other further questions that you want asked, just submit them to me. You can send them directly to me at trish.mcallister@texasbar.com, and join us for future episodes of Ask a Human, because I think we're going to continue to do those next year. And thanks, Patrick.
You bet.